Hello, my name is Paul Keith. I'm the president of the Arkansas Bar Association. The association is a voluntary group of just under 5,000 lawyers in Arkansas and in surrounding states. I'm coming to you today from my office in Monticello. Just over 230 years ago, a very grand experiment began. For the first time in modern history, a government was founded on a unique proposition that the power of the government came from the people and not from a king. For the first time in modern history, the people stood up and told its government, "Your power comes from us. We are in charge." But for you to understand and access the power that you have, you need to know more. So we pause today to understand the source of your power, the United States Constitution. It's not a very long document, it's less than 20 pages, but it is the agreement by which our government operates and by which we regulate our relations with one another. It's my privilege today to introduce to you those who will guide you through this process of understanding the source of your power. Mr. Dan Kemp is the Chief Justice of the Arkansas Supreme Court. He's from Mountain View. He was elected Chief Justice in 2016. Prior to that, he was a circuit judge for almost 20 years, and he was licensed to practice law in 1976. Ms. Courtney Hudson is an Associate Justice of the Arkansas Supreme Court. She's from Harrison. She now lives in Fayetteville. She was elected to the Arkansas Supreme Court in 2010. Prior to that, she served on the Arkansas Court of Appeals, having been elected in 2008. She graduated from the University of Arkansas School of Law with high honors. Honorable Mary McGowan is a circuit judge in the 6th Judicial District of Arkansas. This includes Little Rock. Judge McGowan was elected in 1990. She went to law school at the University of Arkansas School of Law. She's from Conway, and she graduated undergrad from the University of Texas. We won't hold that against you, Judge McGowan. Since 1996, she's been the producer of Gridiron. It's a theatrical satire by lawyers and their staffs. Senator Kim Hammer was elected in 2018 to represent District 33 in the Arkansas State Senate. District 33 includes Saline County and parts of southwest Pulaski County. Senator Hammer also serves as a chaplain and pastor at Saline Memorial Hospice. Ms. Terry Biner is the Dean of the University of Arkansas at Little Rock Bowen School of Law. She is that school's first permanent female dean. She came to the law school in 1994 from private practice with a San Francisco law firm. She is a graduate of Northwestern University School of Law. She has 2 sons and a daughter. Mr. Chad Cumming is an attorney at Gill, Reagan, and Owen, a law firm in Little Rock. He's a graduate of the Bowen School of Law in Little Rock. Before becoming a lawyer, Mr. Cumming taught and held administrative positions in both public and parochial schools for 10 years. Tamara Deaver is an assistant public defender in the Eastern District of the state of Arkansas. She is a graduate of the Bowen School of Law in 2005, and she has served as deputy prosecuting attorney in the 6th Judicial District. She may well have found herself in Judge McGowan's court. Chris Hussain is the chair of the Young Lawyer section of the Arkansas Bar Association. He's an attorney at Legal Aid of Springdale. Chris is a University of Arkansas graduate and a graduate of the University of Arkansas School of Law in Fayetteville. He joined Legal Aid in 2017. Our moderator is Anthony McMullen. Anthony is the Director of Forensics at the College of Business at the University of Central Arkansas. He headed the association's mock trial program for many years and has been instrumental in bringing the national mock trial finals to Little Rock in a few years. Anthony was recently named Debate Coach of the Year by the International Public Debate Association, and he is a lawyer. But before I turn it over to Mr. McMullen, I want to take a moment to thank each of our presenters for giving of their time so that each of you may understand the powers that you have under our system of government. And I especially want to thank our program coordinator, Ms. Beverly Brister from the Arkansas Bar Association. We all believe that teaching you about our Constitution is important work. Mr. McMullen?
Thank you, Mr. Keith. And it is an honor to be here with such a distinguished panel to help educate Arkansas students about the importance of the Constitution and the rule of law in the United States. My role here is basically to ask questions of each of our panelists, and it is my hope that their responses will help you better understand your role as citizens, future voters, and the future leaders of this great country. So my first question is going to be to Dean Biner. And Dean Biner, I'd like for you to explain the basic framework of the legal system in the United States.
Thank you, Professor McMullen. I'm happy to give you a brief overview of the legal system in the United States, and in particular, how the United States Constitution functions within that legal system. The U.S. Constitution is unique in many respects. First and foremost, as Mr. Keith pointed out, it comes directly from the people, not from the states, not from any other governmental entity. It begins with the words, "We the people of the United States." This was really important because it indicated that this was the people's document. It came directly from the people, from you. This was decidedly different than the Articles of Confederation, which was actually the first Constitution of the United States. That Constitution didn't really work too well. It provided the United States with a very weak central government and only included a legislative branch. So a new Constitution was drafted and adopted. That Constitution was adopted in 1787 and remains our Constitution today, some 233 years later. In fact, the United States Constitution is the oldest continuously active codified constitution in the world. It includes Articles 1 through 7 and was signed by the likes of Benjamin Franklin, Alexander Hamilton, and James Madison. This part of the Constitution included the structure of the federal government, as well as a bit about the interaction between the federal government and the states. As other speakers will explain, the three main branches of the federal government, the legislative branch or Congress, the executive branch, which includes the president and the administrative agencies he runs, and the judiciary, which of course is the Supreme Court and lower federal courts, are all set out in this part of the Constitution. It also outlines the powers of these three branches. However, this part of our Constitution didn't include any individual rights. Luckily, it also provided for amendments to the Constitution, and amended it was in 1791 to add the Bill of Rights. The Bill of Rights is the first 10 amendments to the United States Constitution, and it includes a bunch of rights we consider really important, such as the freedom of press, freedom of speech, the free exercise of religion, the guarantee of due process of law, and the right to jury trial, just to name a few of those individual rights. It was written by James Madison with some inspiration from Thomas Jefferson, especially with respect to the religion clauses. Since then, the Constitution has been amended 17 additional times for 27 amendments in all, although there's been a total of 33 amendments proposed. Those ratified include one of my favorite, the 19th Amendment, right to vote regardless of sex. This gave women the right to vote. The 19th Amendment actually was ratified on August 18, 1920, so we recently celebrated its 100th anniversary. Only one amendment has ever been repealed, the 18th Amendment, which prohibited the sale of alcohol in the United States. That was repealed by the 21st Amendment in 1933. The United States Constitution also sets up a divided government, with the federal government having authority in certain areas and the rest of the power going to the states. However, there's a fair amount of overlap. Although thanks to the Supremacy Clause, which is in Article 6 of the Constitution, federal law, including the Constitution itself, is the supreme law of the land when there's a conflict between it and the state or local laws. That's why you see courts occasionally holding a particular state law unconstitutional. The Constitution is written in very broad language. As you'll hear from other speakers today, that makes the courts really important. The courts help interpret the terms of the Constitution in ways that make sense given how the government was designed to work. So there's just a little bit about how our Constitution sets up our legal system and how our government is designed to function.
Now, Dean Biner mentioned the three different branches of government, but Judge McGowan, can you give us a little bit more detail about the different powers of the three different branches and the system of checks and balances that we have set up in our legal system?
Thank you, Anthony. I'd be happy to. And thanks for giving me the opportunity to talk about our brilliant Constitution on Constitution Day, which we're celebrating this year on September 17th. Our founding fathers were inspired when they created our government to contain three branches. The first branch is the legislative branch. On a federal level, that's Congress, made up of the Senate and the House of Representatives. They write the laws and vote them up or down. The second branch is the executive branch. The president, his cabinet, the agencies, governors, all the way down to police officers. They are the enforcers of our laws. The third branch is the judicial branch, the one I'm happily a part of. And the judicial branch interprets the laws. No branch has total control of any other. It is a system of checks and balances. The legislative branch drafts, composes, debates, and passes bills, which become the laws. And the judicial branch interprets them. Sometimes the judicial branch strikes them and renders them null and void. The executive branch enters into treaties with foreign countries, but the Senate must approve the treaties for ratification. The legislative branch has the power of the purse and may withhold funds from the executive branch and sometimes to a degree from the judicial branch. The executive branch appoints federal judges, but the legislative branch, the Senate, must approve them. The executive branch can veto legislative acts, but the legislative branch can override the veto if they have enough votes. These are just a few examples of our checks and balances between the three branches. As James Madison stated, ambition must be made to counteract ambition. The founders designed a system to resist hasty action, prevent undue concentration of power, protect citizens' rights, and forge a national consensus on demanding issues. This arrangement of checks and balances has preserved the original structure of government created in the 1700s, while allowing it to grow to meet the vastly expanded demands of a modern country, the United States of America today. Thank you, Anthony.
I love that overview of the three different branches of government, but I think it's important for our students to hear a little bit more about the specifics of how each of those work. So Senator Hammer, I turn it to you. Can you speak a little bit about the legislative branch of our government and explain the purpose of the legislature in today's legal system?
I'd like to refer to the legislative branch as the branch of the people, because one of the things that we understand in the process is that people have to have a voice in order to get their thoughts and their ideas expressed and formulated into what would eventually become laws. And I would use the analogy of maybe a three-legged stool, that if the legislative branch is not involved in the process, then the stool is unbalanced and the people would not have a voice, and subsequently it would be an unsteady or uncertain environment. So the legislative branch is the part where people can come and express their ideas to us that are elected to the legislative branch, which would be the senators and the representatives. And because we are on the front line with the people, we often hear about the good ideas, about the bad ideas that are coming out of the citizens. And out of all the citizens or recommendations that the citizens make, come the ideas for the laws. The one thing that's important, I think, to know about the legislative branch, especially when it comes to laws that are enacted, is the process. So typically what happens is there's an idea that is generated. Most ideas are brought forth from the people or from entities within the people. that they want to see either turned into a law or they want to go back and modify and tweak a law because maybe there's some unintended consequences with it. And so an idea is born, and then that idea begins to work its way through the process, in that a legislator decides to champion that idea or to begin to move that idea through what are the processes of formulating it into a bill that is then submitted to committees that are broken down within the legislative branch, the appropriate committee that would hear the content of the idea. And through that process, a lot of discussion takes place. And again, that's the good thing about the legislative branch, is that when those committees are going on, the public has access to those committees in order that they can come in and weigh in the process of what will become the finished product as a law. And once the committee decides that it's worthy to go out, then it's put before both branches of the legislative, which would be the House of Representatives and the senators. And as it makes its way through the process, it eventually would become law that the governor would sign. The whole idea behind the concept of the legislative branch is that the people are involved each and every step of the process. They're given opportunity to weigh in on their thoughts as to the laws that are being formulated, and they can express their thoughts, and with the support of the majority of the legislators, that would eventually be enacted into law. One thing that we like as a legislative branch is that once we make the laws, that the judicial branch would then determine how that law is applied in certain scenarios that are brought before the judges. And of course, we as a legislative branch do not like the judges to be legislating from the bench, but that's why we work together with the administrative branch and also with the judicial branch, because we want the laws that come out that are the best for the people and that are the will of the people, because those laws are going to govern the people. And so it's important that the people have a voice in the process, and that's the importance of the legislative branch. We are the voice of the people, and we represent what the people want to be governed by in the ways of law.
Thank you, Senator Hammer. So next, let's hear a little bit about our executive branch. Justice Hudson, can you explain the purpose of the executive branch and explain the basic duties of the executive branch in the United States today?
Thank you, Anthony. To best understand the purpose of the executive branch, we need to first understand what the Constitution says about it. The executive branch is one of three co-equal branches of government, and the other two, as you well know, are the legislative branch and the judicial branch, and that's the one that I'm a part of. The President of the United States is the head of the executive branch for the federal government, while the governor is the head of the executive branch for state government. Now, the framers of our Constitution wanted to build a strong government, but they did not want it to abuse its powers. So what they did was they created a system whereby the power was spread between three different branches of government. Now, remember that the Constitution was written after the colonies had finished fighting a war against an oppressive king. And the colonists had made it very clear that they did not want to serve a king or a queen. And to this end, our country's framers wrote the very first three articles of our Constitution to address this and to provide for three branches of government rather than just one. And they knew that distributing the governmental power between these three branches would keep any one branch from becoming all-powerful. So more specifically, let's talk about what the Constitution requires of the president. The Constitution requires that the President of the United States be a natural-born citizen, be at least 35 years old, and to have lived in the United States for at least 14 years. The president is elected to a 4-year term, but the Constitution limits the president to only serving 2 of those terms, so a total of 8 years. In addition, the president is essentially made the head of state by the Constitution and significantly the commander-in-chief of our armed forces. So what is the purpose? That was your question. What is the purpose of the executive branch? Well, it is to implement and enforce the laws that Congress passes. And the executive branch is importantly responsible for conducting diplomacy with other nations. So it's going to be important that our president get along well with others. As the head of the federal government's executive branch, the president is vested, of course, with a lot of power and duties as well. These include the power to sign into law or to veto legislation passed by the legislative branch. Also, and you've seen this recently, the president may issue executive orders. The president may pardon those convicted of federal crimes. And the president is allowed to appoint all federal judges, and this includes justices on the United States Supreme Court. The president also appoints ambassadors to represent our country around the world, and he or she is allowed to sign treaties with various countries. Now, also, the vice president is a part of the executive branch, and he or she serves as the president of the Senate and stands ready to take the presidency and to serve as as the president if the need were to arise. Now remember, despite the president's very important and significant authority, it is not unlimited, because we have to remember that we just came out of a war with England. That's when the Constitution was written. For instance, the president, of course, may veto legislation passed by the legislative branch, which then prevents it from becoming law. However, the legislative branch may override that veto with a 2/3 vote in both the House of Representatives and the Senate. And any law is also subjected to review by the judicial branch. And of course, that's where I work. Likewise, executive orders are subject to judicial review. And although the president appoints federal judges, it is the majority of the United States Senate that must approve those judges. And in terms of the treaties that the president may sign, well, we have to rely also on the United States Senate to ratify those treaties. So let's talk a little bit about state government. The governor is the head of our executive branch in any state, in the state of Arkansas, of course. And here we require the governor to be a citizen of the United States, to be at least 30 years old, and to have lived in our state for 7 years. In Arkansas, the governor's role is somewhat similar to what the president's role is on a federal level, but there is an important distinction that I wanted to call to your attention. In Arkansas, the governor is not allowed to appoint judges. In Arkansas, the people elect all of the state judges, and that includes the 7 justices on the Arkansas Supreme Court, and that is where I serve you. In addition, we must always be mindful of the fact that because you see on television a governor or a president, and because it's a single person, you might be under the impression that they are all powerful. But please remember that that is not true, and that the founders of our country wanted to prevent that very thing. And the genius of what they did in writing the document, the Constitution, that serves as the foundation of our democracy, is they divided the power between the 3 branches of government. So although the executive branch is very important, not the president and not the governor has all the power. Thank you so much for letting me share with you a little bit about the executive branch. Thank you.
Thank you, Justice Hudson. So before we move on to the 3rd branch of our government, I think it's important to understand why the law is so important. So, Mr. Cumming, can you give our students a little explanation as to the purpose of the rule of law and why it's so important?
The rule of law is an ideal and philosophy on which the United States is organized. It is the idea that we as a people have agreed to run our country by laws. Ultimately, even those who have the most money and the most power in our country are subject to the same laws as everyone else. Now, the rule of law protects the rights of everyone in this country. One way it does this is that our laws are publicly created. It is through the legislative process, as that has been explained. It is created by elected representatives and signed into law by the executive. And this way, the rule of law means that people are informed by what laws they have to obey, and they had a voice in what laws were created. Another way that the rule of law works is that laws are equally enforced. All people and institutions are equal under the law, as I said, and the consequences for breaking those laws are meant to fit the crime, and the consequences are also publicly known. Now, in practice, this doesn't always happen, of course. Important strides in our country's development and history have happened when groups such as minorities have shown that they were not being treated equally under the law. And our courts have come to recognize this. And so important of an evolution of our country is the reinterpretation of laws with the progress of that toward that goal. It is the never-ending process. The rule of law is also a means by which fundamental rights are protected, even by other laws. The most important law, as was explained by Dean Viner, is the United States Constitution. And the trick with laws, especially those where the people have had a voice in them, is that sometimes what a majority agrees is right is actually a violation of those fundamental rights to other people, particularly minorities. As was explained in the Federalist Papers, as I'm sure many students have studied, the Constitution ensures that some laws do not go too far by stomping on the fundamental inalienable rights of some people. Now, all of this is accomplished by independent judiciary. Two of the three branches are subject to political pressure. An independent court system is vital preserving the rule of law because it is not meant to be subject to that political pressure. Now, although the judiciary is independent of those two other branches of government and does not answer to them, the people still do take a part in the judicial system, and they do so through serving on juries, as this will be explained as well.
So I understand that it's important to serve on juries, and I even hear from my students how they don't look forward to the day where they have to serve on a jury. But I promise you, it is really, really important. And it's another way that you can take part in our society. So I'm going to turn it over to Ms. Deaver. Ms. Deaver, can you explain a little bit about the right to a jury trial and how juries work in the United States?
Our Constitution protects the rights of criminal defendants. Before we ever get to a jury trial, every defendant has certain rights that are very important. For example, the right to remain silent. The government cannot make a criminal defendant say anything against their own interest. There's also the right to due process, and due process in layman's terms is the right to call witnesses on your behalf, to confront witnesses against you. You don't have to go to a jury trial. However, you have an absolute right to a jury trial, and it's guaranteed by our Constitution. The beauty of our Constitution is that it recognizes the importance of the people being involved in the government. So a jury is comprised of American citizens. It's a jury of the defendant's peers. It's important that it's a jury of your peers. So the government will pick people from your community. Juries reflect that America is a melting pot. There are jurors from all backgrounds, of all races, of all religions. 13 jurors are selected. Now, I know most people think it's 12, but it's actually 13. There are 12 plus an alternate. The alternate is important because if one of the 12 jurors gets sick, there's someone who's heard the testimony and who can step into that juror's shoes and decide with the remaining jurors, if that makes sense. Basically, the alternate makes it so that the process does not have to start over if one of the jurors gets sick, but the alternate does not vote. To be a juror, you have to agree to be fair and impartial. Getting to serve as a juror is really a privilege. It's the ultimate patriotic duty. When you sign on to be a juror, you agree to be fair and impartial, and you agree to see that justice is done. In my career, I've had, I don't know how many jury trials, several, I've lost count. I really do believe that jurors take their duty seriously, and I believe that they reach the right verdict most of the time. Actually, the great majority of the time, they reach the right verdict. As a juror, they sit and they listen to all of the testimony. The judge will instruct them that they can use their own common sense, that they can assess the credibility of witnesses for themselves. Once they hear all of the testimony, the judge will give them what's called jury instructions. The jury instructions explain the law, the purpose of the jury, and most importantly, they contain the verdict form. And the verdict form is guilty or not guilty. I cannot stress enough that being a juror really is a privilege and an honor. If you're ever called for jury duty, be thankful that you have that opportunity, and I hope to see you on my jury someday.
Thank you, Ms. Deaver. So now, earlier we heard about the legislative branch and the executive branch, and now it's time to hear a little bit about our judicial branch. And so for this, I turn to Chief Justice Dan Kemp. Justice Kemp, can you explain a little bit about the Arkansas appellate courts and the types of cases that they take?
Oh, yes, Anthony, thank you. The Arkansas appellate courts are courts of review. We're not trial courts like Judge McGowan. She sits in the trial court, the circuit court, where trials are conducted, witnesses are testifying, and the jury or the judge finds what the facts are. But the appellate courts review those trials on appeal, and we just look at the record that's typed up and written out to determine whether there's been some law or fact that is improperly found or determined that would prevent a person from having a fair trial. The jurisdiction of the Arkansas Supreme Court is set by law, and there are certain cases that are required to be heard by the Supreme Court. Under Arkansas Supreme Court Rule 1-2A, the following type cases shall be filed in the Arkansas Supreme Court. Those will be all appeals involving the interpretation or construction of the Constitution of Arkansas, criminal appeals in which the death penalty or life imprisonment has been imposed, petitions for a quo warranto, prohibition, injunction, or mandamus directed to the state, county, or municipal officials or to circuit courts, cases pertaining to elections and election procedures, appeals involving the discipline of attorneys, or arising under the power of the Supreme Court to regulate the practice of law, appeals involving the discipline and disability of judges, also second and subsequent appeals following an appeal that's been decided by the Supreme Court, and then other appeals required by law to be heard by the Supreme Court. All other appeals are heard by the Arkansas Court of Appeals. And sometimes the Arkansas Court of Appeals will hear a case, and a party in that case may not be satisfied with that decision. So the party can file what's called a petition for review with the Supreme Court. And the Supreme Court has the discretion under Supreme Court Rule 1-2B to decide whether to take that case. And some of the factors that the court considers and whether to take that case are whether it's an issue of first impression, whether it's an issue that pertains to some inconsistency between decisions of the Court of Appeals and the Supreme Court, issues involving federal constitutional interpretation of the U.S. Constitution, issues of substantial public interest, significant issues that need clarification or development of the law or overruling of precedent, and also appeals that involve substantial questions of law concerning the validity, construction, or interpretation of an act of the General Assembly, or an ordinance of a municipality or a county, or a rule or regulation of any court, administrative agency, or regulatory body. So those are the type cases that the appellate courts in Arkansas hear.
Thank you, Justice Kemp, for telling us a little bit about the judicial system. So you've heard about the three branches of government, but what is it actually like to have your career all about the law? So, Mr. Hussain, why don't you tell us what it's like to be a lawyer and some of the steps that are necessary to become a lawyer?
Thank you, Anthony. I'm happy to. Being a lawyer is a great privilege and it's a great responsibility. Going into being a lawyer, a lot of people may not think this, but you are dealing with people's lives every day. It's fun. It's definitely not easy. You're definitely busy all the time. An average week for me, I spend my time, most lawyers do, at least for the most part, spend their time doing three main things, I would say, and that's meeting with clients, drafting documents, and then representing those clients in court, which I have the ability, or I'm fortunate enough to do pretty frequently. I'm there once a week, if not multiple times a week, and that's absolutely my favorite part. As far as steps to become a lawyer, there's definitely a set way to do it. First, you're going to want to go to college and graduate from college. While you're there, you're going to want to take the LSAT, which is the test that you take to get into law school most of the time. Once you have your LSAT score and you've got your GPA or close to it and you're ready to almost graduate, you'll start applying for law schools. You'll pick a law school, hopefully that you'll get accepted into one, go to law school. You'll graduate from law school in 3 years. That's the normal amount of time. And then you'll start studying for the bar exam. Usually people study 2 to 3 months for the bar exam, as the first one's generally given July after the May graduation for law school. You'll wait 5 weeks for your bar exam results. And then if you've passed, you are now a lawyer and are able to practice law once you are sworn in. If you don't pass the bar, then you get to start studying again and take it, and you're able to sit for it again and have a chance of becoming a lawyer later. Now, the purpose of lawyers in the legal system, I feel there are a couple purposes, really. Lawyers wear many hats. Usually lawyers are seen as advisors and advocates. As lawyers, we advise our clients on their rights and obligations under the law, and we also serve as their advocates if we're filing something for them in court, or going to court to represent them, to speak behalf on them, to put their position forward. Lawyers also are responsible for adhering to the rules of the law, the rules of evidence, the rules of procedure, and making sure that those are followed, and that if they are defending someone or if they are representing the state, that either party is getting their fair shake and that the rules are being followed how they're supposed to. When it comes to what people can do if they can't afford a lawyer, they have a couple of options. In criminal matters, we have what are called public defenders, and you heard from one earlier, Ms. Deaver. And if someone is poor or can't afford a lawyer, they can be appointed a public defender in their criminal case. Now, in all other matters that aren't criminal, which we call civil matters, there are often nonprofit or private entities that will provide legal services for low-income clients or people that can't afford private attorneys. So I work at one of these organizations. I work at Legal Aid of Arkansas. We're a nonprofit, and we provide civil legal services for low-income Arkansans, as well as our sister organization, who is the Center for Arkansas Legal Services, covering the other half of the state. Outside of those two options, public defender or a private legal aid society, if someone is unable to afford an attorney, their other option would be to represent themselves.
Thank you for that great overview. Thank you, Mr. Hussain, and thank you to all of our panelists for all the work that you do to make our system in Arkansas stronger and better. So, one final word that I have. I hope that you are really interested in learning more about the legal system. And the Arkansas Bar Association provides a couple of opportunities for you to compete and hopefully win a few accolades. First is the mock trial competition, where students get to play the roles of attorneys and witnesses and simulate an actual trial and get to perform that trial in front of real judges and real attorneys. You also have the Spend the Day with the Judge competition, where you can either compete in our essay contest or our courtroom artist contest. And the finalists in both of those competitions get to, as the name of the competition implies, spend a day with the judge in Arkansas. And both Judge McGowan and Chief Justice Kemp have participated in this great program. So with that, I hope that you've enjoyed learning a lot more about the Constitution and the rule of law in Arkansas. And so, as a final message to you, I turn it over to the organizer of this program, Beverly Brister.
Thank you, Anthony, and thank you to all of our presenters today. I hope you have enjoyed this review of the legal system. It has been brought to you today by the Legal Related Education Committee for the Arkansas Bar Association.